Sunt foarte încântată să fiu aici, mă simt ca acasă, deși n-am pus niciodată un picior la Ministerul Afacerilor Externe. Et en particulier, je me retrouve avec un peu ma famille adoptive, mon chef Alain Pellet et Daniel, qui a été comme un frère pour moi depuis vraiment très longtemps. Et donc, ça me fait vraiment plaisir d'être là aujourd'hui. I will do the rest of my speech in English. And I will just start directly with the topic, which is not really a burning issue, because I'm going to speak about a 1927 advisory opinion of the Permanent Court of International Justice on the powers of the late European Commission of the Danube on a small portion of the river between Galați and Brăila. So that's normally a small issue. Still, it is an interesting topic on more than one account. That was Romania's first case, if I can call it like that, before the Hague Court. And it became a good pretext for me to dive into history. And as every self-respecting internationalist, I started with the history of international law in Romania. And I noted that the advisory opinion coincided with a period of great interest for international law among Romanian academics. As Bogdan Aurescu recalled this morning, just a few years before the advisory opinion was given, Vespasian Pela had written his books on international criminal law, a book of great influence. The advisory opinion itself increased the taste for international law in Romania. Some years afterwards, the Romanian judge Dumitru Negulescu delivered the Hague academic course on the advisory opinion systems, and Judge Kitt recalled this morning the influence and the contribution of this course to the understanding of the system of the advisory opinions. Again, in the 30s, around the same years as Dumitru Negulescu's course, there was another Negulescu, now Paul Negulescu. I don't know if there is any family link, I could not retrieve it between them. So Paul Negulescu gave a very good course on international administrative law, and a very far-reaching, because now the International Administrative Law School is very much influenced by that course. And I must also mention that around the same period, Mircea Juvara was called to deliver a course on the theory of international law. And then it stopped. Mircea Juvara published his course in 1938, and until 1985, no other Romanian professor came to deliver a course at the Hague Court. I just hope that the delimitation case will initiate a similar trend of international law, of interest for international law in Romania. And I hope this conference is just the beginning of that. Now, my presentation is also a good pretext to dive into the big history, the history of Europe and in general, and of Romania in particular. The advisory opinion is first a reflection of the European history during the 19th and the beginning of the 20th century. Because the powers of the European Commission of the Danube are merely a mirror of the succession of empires, of the rivalry between the Orient and the Occident, and it also has a flavor of Mittel Europa. The Treaty of Paris of 1856, setting up the first Danube Commission, was a direct consequence of the defeat of the Russian Empire during the Crimean War, by an alliance of the French Empire, the Sublime Gate, by Great Britain, and Sardinia too. And this explains why the parties to the 1927 advisory opinion were France, Great Britain, and Italy on the other side, on the one side, and Romania on the other, Romania being a successor of the Ottoman Empire. By its physical presence at the mouth of the Danube, the Commission was in fact a symbol and a sentinel of the political interest of the West in preserving southeastern Europe and Turkey from Russian domination. The Treaty of Paris entirely internationalized the mouth of the river from Galați to the sea first. The Commission was thus transferred powers to regulate navigation on the river under all its aspects. The purpose of this transfer was very comprehensive. It was to ensure freedom of navigation for all flags under a uniform law, uniformly administered. So the Commission was not intended merely to dredge channels. In addition to carrying out technical work, it established taxes, it maintained its own vessels, its own police force, and its own courts. These are really extraordinary powers. Therefore, it is for good reason that the Danube Commission was metaphorically called an état fluvial. Romania, a newly independent state, considered these powers to infringe upon its own sovereign jurisdiction. Indeed, we must resituate the 1927 advisory opinion against the background of Romania's history. The opinion was given less than a decade after what we call the Great Union of 1918, when Transylvania was annexed to Romania, and some 50 years after Romania's independence from the Ottoman Empire. Romania's position during the 1927 proceedings it actually fully reflects its foreign policy at that moment, during the interbellic period, the gist of which was the consolidation of territorial sovereignty, but also integration among the concert of nations, as it was called at that time. Therefore, the proceedings bear witness of Romania's attachment to the League of Nations. Although it had not accepted the court's jurisdiction to settle the dispute on a contentious basis, Romania agreed the matter to be submitted to the court for an advisory opinion. And then the court was seized by a question of the Council of the League of Nations. Now, on substance, Romania's position was defense of territorial sovereignty. This meant, in that case, the suppression of territorial servitudes it had inherited as a successor state from the Ottoman Empire. Thus, Romania's position in relation to the subject matter submitted to the court was to agree that the Commission had the technical powers to engage into works for maintaining navigability on the river, and to dispute that it had any normative powers, as it was called at the time, namely powers to establish taxes and regulations, police powers, and jurisdiction powers. Therefore, it can be said that the essence of the dispute before the court concerned the powers of the Commission and their layout with the sovereign powers of the Romanian state. However, the court's decision goes beyond this strict legal framework, since it put in fact the basis of the law of international organizations, or institutional law as we call it today. I will first focus upon the underlying legal principles, the modernity of which is quite striking. The first problematic issue the court had to deal with was to determine whether Romania was at all bound by the regime established by the great powers. Indeed, Romania was not a party to the 1856 Treaty of Paris establishing the Commission. It must be added that, though fully independent since 1878, Romania was not admitted to participate to the Berlin and London conferences of 1878-1883, which extended the powers of the Commission between Galați and Brăila. And in fact, the participation to international conferences of the time was considered to be a privilege of great powers. On the other hand, it was not contested that the Ottoman Empire was a party to all these treaties. However, it was not by succession to treaties that the court held Romania to be bound, because it had not needed to go into this concept, which was not stabilized at the time. What happened is that Romania had ratified the Treaty of Versailles and the definitive statute of the Danube in 1921. And both these treaties recognized that the Commission would exercise the same competencies as before World War I. And indeed, Article 41 of the definitive statute expressly provided, and I'm quoting, that all treaties, conventions, acts, and agreements relative to international waterways generally, and particularly to the Danube and its mouth, which were in force when the statute was signed, are maintained in all their stipulations, not abrogated or modified by the statute. End of quote. Because of this, let's call it referral clause, the court held that the definitive statute was not complete in itself. Therefore, prior obligations were incorporated into it and became, by this token, opposable to Romania. The court could thus hold Romania's ratification of the statute to worth consent to these prior obligations. I've insisted a little on this mechanism of referral clauses and used the term on purpose. The term is not in the advisory opinion, just to flag the modernity of the reasoning of the court. The present court itself was confronted to the effect of these referral clauses. Let me just quote the pulp mills case, in which the statute of the Uruguay River was referring to other international obligations of both states. For various reasons, in the pulp mill case, the court did not consider this referral clause to be worth incorporation of the prior obligations into that statute. Now, the second problematic issue the court had to deal with, the permanent court had to deal with, was that of determining the extent of the powers of the Danube Commission. Again, its reasoning was really remarkable of modernity and greatly inspired the law of international organizations. The 1927 advisory opinion laid the basis of essential principles of institutional law, such as the principle of enumerated powers, the principle of implied power, and also the principle of interpretation of the treaty via institutional practice. I will deal just briefly with each of these three principles. First, the principle of enumerated powers. We know it. An international organization has only the powers vested in it by the Constituent Treaty. And in this advisory opinion, the court stressed that the Danube Commission, despite its exorbitant powers, was not an organization, and I'm quoting, possessing exclusive territorial sovereignty. And it added, as the European Commission is not a state, but an international institution with a special purpose, it only has the functions bestowed upon it by the definitive statute with a view to the fulfillment of that purpose, end of quote. Now, the most obvious consequence of this assertion is that the state enjoys the plenitude of powers over a territory, while the international organizations acting on the same territory has only the powers enumerated by the Constituent Treaty. Was there to be a concurrence between the two? The court said no. And let me quote the sequence in the advisory opinion, which I found the most dense and far-reaching from this point of view. The court said, when in one and the same area there are two independent authorities, the only way in which it is possible to differentiate between their respective jurisdiction is by defining the functions allotted to them. Now, we can retrieve in these short passages all the elements of the modern theory of international organizations. The concept of functions lies at the heart. It accounts for the nature of the organization. In fact, the court said that an organization is a legal creature, but it's saying the same for the state. However, a state is a complete subject with a general competence impersonating territories and people, whereas international organizations are merely institutions created by those states for a specific purpose. Therefore, their raison d'être is not inherent, but rests within the purpose which was attributed to them. And indeed, international organizations tend to merge with the functions attributed to them. Now, to an international lawyer's mind, this reasoning is very familiar. It makes us think of the ICJ's celebrissime dictum in the reparation for injuries case, where the court held that the United Nations enjoyed legal personality, which the court said is not the same thing as saying that it is a state, which is certainly not, or that its legal personality and rights and duties are the same as those of a state. All of a sudden, in the light of the permanent court reasoning in 1927, this seems less revolutionary. What is surprising is that in 1945, an issue arose about the legal personality of an international organization, a question taken for granted in 1927. The two opinions are, however, also complementary in the sense that it is by reading them together that we conclude that the personality of an international organization is a functional one. And I'm turning to the principle of implied powers. The 1927 advisory opinion bears the first mention of this principle. The court stressed that the Danube Commission has powers to exercise its functions to their full extent. Even if some means of actions are not expressly provided for in the Constituent Treaty, the organization is still held to enjoy them as long as that action is necessary for it to fulfill its purpose. We know how much this principle influenced the development of international institutional law and how strongly it was upheld in the certain expenses and reparation for injuries advisory opinion. The last aspect I wish to stress out concerns the role of the institutional practice for the interpretation of a constituent treaty. In fact, if the extension of the powers of the Danube Commission was a contentious question at all, it is because it resulted not from the treaty directly, but from the practice of the Danube Commission during the 19th century. At the end of the century, the Commission had gradually elaborated regulations and took measures for that portion of the river between Galați and Brăila. Before the court, Romania challenged the legality of these regulations. However, the advisory opinion recalls that in this usage, the Romanian delegate tacitly but formally acquiesced. Therefore, the court acknowledged that tacit acquiescence in institutional practice is source of powers for the international organizations and also of correlative obligations for the states, for the member states themselves. And this is another far-reaching finding. For instance, very recently in the whaling case, the ICJ was again confronted to the effect of institutional practice. The International Whaling Commission had adopted over the years a series of resolutions concerning scientific whaling. And Japan contested their legality on grounds that, according to the 46th Whaling Convention, the Commission was not endowed with power to deal with the scientific whaling. Now, this case, as you know, is sub judice, so I'm not going to comment upon it more. Today, this principle, the enumerated powers, the implied powers, institutional practice for the influence of institutional practice on the interpretation of the treaties, seem so consolidated that they look like just technical maxims of institutional law. But I still have some time? Okay. As the advice, I should ask the public. However, I was saying that these principles are today consolidated. However, in 27, they were really new principles, and they were first held as a way to formulate and resolve the tension between state sovereignty and decisions taken by international organizations, binding decisions taken by international organizations, sometimes against the will of the states themselves. In the 1927 advisory opinion, the court resolved that tension by constantly referring to Romania's explicit or tacit consent to these obligations. Thus, for the permanent court, participation in international organizations endowed with powers to create new legal obligations was just another form of international commitment. And these legal principles were meant to strike the right balance between sovereignty and enhanced international cooperation through international organizations. It seems, however, and this is going to be my concluding point, that this balance was precarious. To be sure, the principles survived, but not the model of international organizations formed by the river commissions as they existed during the 19th century. Indeed, no organization exists today having powers as extended as those of the river commissions. The present Danube Commission is formed by riparian states alone. It has no power to take binding decisions. It can only supervise the technical works on the river. Its means, normative but also, I suppose, budgetary, are just like its missions, greatly reduced. And this is certainly due to the context of the adoption of the 1948 Belgrade Convention, but also I think it is also due to the consolidation of the principle of equal sovereignty during the 20th century. Why? Because the 19th century commissions were set out by states victorious in war as a form of securing their interests beyond their territory. The membership in these commissions reflected this essential purpose. Riparian states, but also non-riparian states, were put on an equal footing in those commissions. No wonder that this model could not survive during the 20th century. And even the Rhine Commission, which actually functions quite well, has lost some of its powers. But it is much more effective than the Danube Commission because it has a power to decide the law. The Danube, it's still in search for its model. I'm aware that at least since 2005, there is a new convention that is being negotiated to set up a more effective commission. We discussed about that in 2008 when we had a conference in Paris. It was one of the big subjects, but nothing moved since then, so I suppose things are at a stalemate. I'm also aware that there is this, the new European Union strategy for the Danube region, which has attracted a lot of interest since 2008. But as I read on the Ministry of Foreign Affairs website, this program was conceived under the constraints of a triple no. No new funds, no new institutions, no new regulations. Then I can only conclude with the question, thus conceived, may this new strategy live up to the promises of the Europe's longest second river? So, thank you.